Good morning, Dr. Emily. I am doing week 7 presentation. My first question is, what is customary international law and what elements have to be shown for it to exist? Customary international law is unwritten law deriving from practice accepted as law. They are among the source of international law listed in Article 38, paragraph 1 of the Statute of International Court of Justice, which refers to international custom as evidence of a general practice accepted as law. It remains an important source of public international law. The two elements that have to be shown for it to exist are one, general practice. It refers primarily to the practice of the states that contributes to the formation or expression of rules of customary international law. Practice may take a wide range of forms and may include both physical and verbal acts and must be sufficiently widespread and representative as well as consistent. The second element of the customary international law is acceptance of the practice as law. That means opinio juris. What it means is that the practice in question must be undertaken with sense of legal right or obligation and is to be distinguished from mere usage or habit. Together, they are essential conditions for the existence of a rule of customary international law. The presence of only one constituent element does not suffice for the identification of a rule of customary international law. Practice without acceptance as law means opinio juris, even if it is widespread and consistent, can be no more than a non-binding usage, while belief that something is or ought to be the law unsupported by practice is just mere aspiration. It is the two together that establish the existence of the rule of customary international law. Therefore, identification of such rule thus involve a careful examination of available evidence to establish their presence in any given case. To establish that a claim concerning the existence of or the content of a rule of customary international law is entail a search for a practice that has gained such acceptance among the states that it may be considered to be the expression of a legal right or obligation, namely, that it is required, permitted, or prohibited as a matter of law. The test must always be, is there a general practice? And if there is general practice, then is that general practice is accepted as law? UN General Assembly resolution from December 2008 provides a summary of the way in which the customary international law can be identified. And there are some of them which I have listed here. So first is treaties. A codified rule set forth in treaty may reflect a customary international law, but despite of number of treaties, that rule set forth may not indicate that it reflects a rule of customary laws. Second, resolution of international organization and intergovernmental conferences. That means a resolution itself cannot create a rule of customary international law, but it may provide evidence of determining if there is an existence and content of the customary international law that contributes to its developments. Decisions of courts and tribunals. Decisions of the International Court of Justice are subsidiary means for existence and determining of the customary laws. Means in some way it reflects the customary laws. Teaching of the most highly qualified publicist of the various nations serves a subsidiary means for the determination of the rule of customary international law. Other resources are public statements made on behalf of the states or government, official publications, government's legal opinions, diplomatic correspondence, decisions of international court, treaty provisions, conduct in connection with resolutions adopted by international NGOs, etc. etc. Now the second question is, what is the significance of International Court of Justice decisions in public international law? Are they binding on states? And how do they operate as a source of law compared to, for example, High Court of Australia? Sorry, excuse me. There are some general principles of law that are derived from the specific nature of international community. These principles have no direct counterpart in domestic law because they came from the nature of international system. Article 38 1D states that the judicial decisions are source of law and are binding only upon the states or the parties to the disputes and have no binding effects on any other states. Although judgments of the ICJ do not have binding forces as precedent, occasionally the judgments of the court have made significant contribution in developing a particular area of law. For example, the criteria formulated to recognize baseline from which the territorial sea can be measured in the fisheries case was later used as a example or base to draft Geneva Convention on the Territorial Sea in 1958. Article 38(1) of the ICJ statute refers to custom as a general practice accepts as law, which requires that states believe themselves to be under a legal obligation to follow the practice. However, states are considered as an abstract legal personality or legal person. The influence and impact of international law is often thwarted by the failure of states to implement the law at a domestic level because the states are often reluctant to cede control over their domestic affairs. So, having much flexibility and freedom and avoid giving international law a superior position in the domestic sphere. That is the reason why states are reluctant to apply these international laws. International law is exerting an increasing influence over the domestic sphere. As Justice Kirby explained, there is an evolution of a new relationship occurring between domestic and international law. Many cases which requires the application of international law and application of the international human rights and jurisprudence fills the gaps that are in our common law and provides the guarantee of fundamental human rights and freedom. The high degree of flexibility that accompanies international law in the domestic arena results in a situation where the ultimate influence of international law depends upon state involved. For example, the landmark case of Mabu versus Queensland, number 2, affirms the importance and influence of international law in the judicial decision making in Australia. Various judicial authorities have concluded that the treaties, which is a type of or source of international customary law, which can recognize as a source of international customary law, one of the source, the treaties cannot become a part of Australian law until it's transformed through a legislative act. Treaties play an important role in influencing state decisions and the bodies that are decision making bodies and the judiciary. The case of Teo is a good example of influence on judiciary. It resulted in the extending impact of ratification to an act creating obligation upon the states and its agency to inform themselves of Australian treaties treaty obligations, and to act with awareness of these international obligations. I also remember from reading of one of the article that which it I just included here, Justice Kirby's comment. He actually explained that because states and we are reluctant to apply the international customary law in our domestic practice, now the influence of the international customary law is widespreading and it is become a necessity in many cases, and lawyers and our justice system needs to be prepared and to be educate with that international laws to be able to apply when it is necessary. So this is the end of my presentation. Thank you and have a nice day.